I believe we have everybody online now. Good morning and welcome to this online hearing of the Committee of Adjustment of the City of Ottawa under the Planning Act. This video conference is also live streaming on YouTube. With me are my fellow panel members, Jocelyn Chandler, Stephen Lewis, Terrence Otto, and Martin Vervoort. My name is Fabian Poulin and I will be chairing this hearing today. The procedure for this hearing will be as follows. Listed on the agenda and appearing on the screen are applications we will hear today. For the sake of efficiency, the committee may deal with agenda items in a different order. Committee members have reviewed the planning reports and any written submissions in support or in opposition of each of the applications. Today, we will have oral submissions from any interested party. Notice regarding minor variance applications, notwithstanding pre-consultation with city staff, is the responsibility of the applicant to identify all required variances accurately on the application to one, add a new variance or increase the extent of the variance requested. It must be given in accordance with the Planning Act and may require the application to be recirculated for the next hearing date at a cost to the applicant at the prescribed fee. If an applicant amends their plans with no impact to the variances or to reduce the variances requested, recirculation may not be required. As part of the statutory notification requirements, each applicant was required to post a sign on the property and file a statutory declaration confirming the sign posting. This declaration must be on file today before we can hear the application. Without it, I may have to adjourn the application or administer an oath if necessary. Can the coordinator confirm that we have received all the statutory declarations?
Yes, we have received them all.
So I do not have to administer the oath to any of the applicants.
One second, let me confirm that.
Mr. Chair, I don't know if we have received statutory declarations. It may be worth administering the oath in the abundance of caution.
I will do that. Thank you very much, Deputy Secretary. The committee may ask for a brief presentation of the application, followed by questions from members and submissions from the public. Please address your comments to the chair, starting with your name, spelling it if necessary, and your municipal address for the record. The committee limits presentations to 5 minutes. Any exceptions will be at the discretion of the chair. And before we begin, we have 2 items of business to address. Does any member present need to declare an interest in any of the applications that are before us today or are on the agenda of another committee panel? No declarations of interest. We also have to adopt minutes of several last public hearings. We have to adopt minutes for April the 6th, April the 20th, May the 4th, and May the 18th. Panel, are you okay with us doing a blanket approval of all 4 of these? Okay, so I'll ask for your approval of all 4 all 4 minutes. Please raise your hands if you agree. All right, we'll now move forward to those items that would like to be adjourned. I believe we have 2 items that are looking to be adjourned. And those items, first item is item number 7, 4772 Boundary Road. Mino DeClear, are you available, sir? Or ma'am, I'm not sure.
I believe the agent is Mr. Bax.
Yes, Dennis Bax, I'm sorry. Mr. Bax, are you available? Yes, I see your name there. You're muted, sir. Still muted. Oh, I see you now, sir. You're still muted.
Sorry about that.
Oh, that's okay. There you go.
Yep.
So there's a request for an adjournment of this application. Sir, are you in agreement with that?
At this time, yes, there's a minor variance that was missed. I did go through a development officer, two of them actually, and I guess the lot area or the actual size of the building was missed in the minor variance application. So we will adjourn at this time. I agree with that.
Okay, the adjournment is for sine die. So are you in agreement with that, Mr. Harrigan? I believe you're the planner on file.
Through you, Mr. Chair, it's Mr. Kirkkonen.
Thank you, Mr.
I
Kirkkonen.
am the planner on file, and yes, the request is for sine die for the new variance and for recirculation.
Okay, thank you. Mr. Bax, you agree with a sine die adjournment?
I do agree. I do have one question. I don't know if this is the proper time to ask. The other comment that was brought up with the application was a conservation study to be implemented. Some of the documents that I did receive are from the South Nation, and they say there is no issue with heritage, or exact statement is did not identify any natural heritage features or natural hazards associated with the application. So can this be settled, or do I have to submit it again when I resubmit?
I think you'll be able to resolve all the issues before the next application through the different channels, either through the Conservation Authority
Okay.
or through Mr. Kirkkonen.
Mr. Kirkkonen. Okay, thank you very much.
You're welcome.
I thank the board.
Panel, you agree to adjourn this application sine die? Please raise your hands. Applications adjourned sine die, sir. Thank you very much.
Thank you.
I'll move on to application number 7. We did that one. Application number 9. This has to do with 7661 Mansfield. And Mr. Webster, are you available? I see you, Mr. Webster. You're muted, sir. There you
Okay.
go. Good
Good
morning.
now?
Yep,
Good
I can
morning.
hear you now.
Okay, great.
So, Mr. Webster, there's a request to have this application adjourned. Are you in agreement with adjourning this application sine die?
I don't understand why it would have to be sine die. I don't get that. That's a lot of money for the guy to throw back at it later, isn't it? Like what would,
Well, I won't respond to that, but you've had since January to get this thing, get
Yeah,
the
no,
information
I-
into
I've
planning.
been, yeah, I get it. But I phoned Novatech because now I have to do a mineral resource impact assessment, and they're like a month and a half, 2 months behind. And there's just so many other things, but I'll go with whatever you guys are going to make me do. I'm doing it. So
Okay.
tell me what
So-
you want.
Okay. And I'd like to ask the planning department if they could comment on Mr. Harrigan, are you interested in a sine die adjournment to this application?
Thank you. Through you, Mr. Chair, the planning department would like to see a minimum of about 3 or 4 months for an adjournment request, but I would like to confirm with the panel members if an adjournment sine die is required for recirculation. So if you look at the severance sketch, they proposed one severance, which is labeled number 2 on Mansfield Road. That's within the agricultural resource area. And it does have to be relocated to the north half of the property. And the closest available spot would be directly north of severance number 1, which is about 800 square meters away and on a new road. So I want to ensure if we are doing any adjournments now, if recirculation is required, I would rather do the recirculation now and do sine die than adjourn this for 3 months only to have to do a recirculation then.
I think, in my opinion, I think we need to do the recirculation. Therefore, I would suggest a sine die adjournment. I'd like to ask panel for their comments. Ms. Chandler?
Well, if a recirculation is required, we may as well adjourn it sine die. The costs are the same, and that'll allow the applicant to get everything sorted. Don't really want to see this come back again.
Thank you. Mr. Lewis? You're muted, sir.
Usually I'm on top of those problems, but I'm open to whatever the rest of the panel wants to do.
Okay. Mr. Otto?
Jocelyn.
Thank you. Mr. Revort?
I agree with Ms. Chandler's comments.
Okay, very good. So I'd like to ask the panel for approval to have this application adjourned, sine die. Please raise your hands if you agree. Okay, your application is adjourned, sine die, Mr. Webster. Thank you.
So is there a timeline on when I reapply or just reapply whenever I reapply?
Reapply when you get all the information together.
Fantastic. Fantastic.
Okay, thank you.
Very much. Thank you.
Now we'll move on to items in order, except that we will be doing items number 1, number 11, and 12 all at the same time, since they have to do basically the same property. And I believe Mr. Price is the applicant, representing the applicant today. Mr. Price, are you available? You're muted, Mr. Price.
Good morning, Mr. Chair, members of the committee. So I'm just trying to fiddle here with my Zoom icon.
Okay.
Good morning. Sorry about
Good
that.
morning. That's okay. So we're going to deal with your applications 1, 11, and 12, since they deal basically with the same property.
Okay.
So to that end, I note, the panel notes that there are no concerns with respect to item number 1, which has to do with 173 Rivington. And there are, in this case, notes here.
Oh, apologies, Mr. Chair. I think we have to take the oath regarding the sign postings first.
Good point. I have it out here too. Thank you. Can you take the oath, Mr. Price?
Yes, Mr. Chair, I can.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
I swear, Mr. Chair.
Thank you. So going back to, we don't seem to have any concerns for your first application, where we have 4 minor variances. So I note that planning does not have any concerns and Conservation Authority does not object. So I'd like to ask the panel if they have any comments. Mr. Otto? No comment.
No
Mr.
comment.
Lewis?
Thank you.
No comment if everybody else is okay with it.
Okay, Ms. Chandler?
I don't have any additional comments. Thank you.
Thank you. Mr. Verwoerd?
I don't have any comments on any of the 3 applications. I think they're all in order, but I guess just for the record, maybe we just want to approve them one at a time.
Yeah, so that's what we've got right now. We've got, we're dealing with application number 1 that has 4 variances, 4 minor variances, having to do with reduced 21-A-0029, permit a reduced lot area of 183.1 meters, whereas the bylaw requires minimum lot area of 240. You suggesting I read them all into the record, Mr. Verwoerd?
I was just going to say, if we just refer to the refer to the agenda item number or the application numbers, that would be fine, just so it's clear.
Okay. So the agenda item number 1, there are 4 variances. I'd like to ask the panel for approval of this application, all with 4 variances. All in favor, please raise your hands. Application number 1 is approved. Mr. Price?
Thank you, Mr. Chair. These are for the variances only, Mr. Chair. Sorry to interrupt.
Yep, we're going on to the next one, which will deal with your consent applications.
Okay, that's where I would like a moment of your time. Yeah.
Okay, that's fine. Yeah, because we have different items here. Yes.
Understood. Yeah.
Yeah. So application number 11. This has there are 5 consent applications dealing with this one. The Planning Department and the Conservation Authority do not have any concerns. However, planning does have 5 conditions. Are you familiar with these conditions, Mr. Price?
I am, Mr. Chair, and with respect to condition 2 and the road widening, I know staff have been instructed to take road widenings wherever possible. However, in this instance, I don't think it's appropriate, given that nothing came off the neighbors immediately adjacent. The road terminates at a dead end cul-de-sac, 2 blocks of townhouses to the east. We're just looking for the same treatment as the adjacent neighbors next door. There's a road widening that occurred kind of across the street from Rivington. However, any road widening that was taken would be taken off this property would never be able to be utilized down the road, because the adjacent properties to the east don't have the same, weren't treated in the same fashion. That would be addresses 175 Rivington down to 189 Rivington. So in order to maintain that consistency along that north portion, Rivington, before it terminates at the cul-de-sac, we're just looking for the same treatment.
Thank you, Mr. Price. Mr. Kilconen, do you have any comments?
Through you, Mr. Chair. Thank you for those comments. It is a directive of the official plan. I believe Mr. Harrigan spoke to this during our last hearing, that we are to request road widenings as a condition of severance. Those severances may have been approved in the past prior to our new directives, and therefore should not apply in this situation. If we were to approve of this application without this condition, it would just be another property in which expropriation would be the only option if a road widening were to ever be required.
Mr. Price, does this property run right into a cul-de-sac?
It does, Mr. Chair. If you go 2 blocks of townhouses to the east, it goes into a cul-de-sac, and what that cul-de-sac is terminated because the next land use is a floodplain. So the likelihood of this road ever being extended beyond that cul-de-sac in my lifetime, my girls' lifetime, and their children's lifetime is next to impossible. There is a portion of land on the other side of that floodplain that this road may or may not, back in the day, have been included, where it is zoned development, future development, before you get into agricultural. But for all intents and purposes, I understand what staff is saying, and they're given directives through the OP. That doesn't necessarily mean that the committee has to make the same decision where it's not appropriate. And I think in this instance is a perfect example whereby, if the road widening were to be taken, again, it was not something that was raised through pre-application. This application was submitted over a year ago, and it was adjourned at the request of the applicant as we added the 4th unit and negotiated with the abutting neighbor for the land swap to get an additional unit in there. It's never come up. And so, we've gone through the process, we've gone through public consultation. The lands immediately to the east, as I mentioned, 175 to 189 do not have the same road widening requirement. And the fact of the matter is, this road will never be widened. And I understand the directives of the OP, and where appropriate, it makes sense. But I think in this instance, given that it terminates at the end, call it maybe 80 meters down the road, in this instance, I don't think it makes sense.
Thank you, Mr. Price. Sorry, go ahead.
And I guess ultimately, this is new information to us and the client. How does that impact the variances in terms of lot coverage and front yard setbacks, right? We've got the same setbacks as the abutting neighbors, 6 meters. And if you were to take 6 meters off the abutting neighbor, or even 2 meters, you're down to a smaller front yard setback. So you're gonna have an inconsistent streetscape as this street develops. So it's something as older lots to the west come on board, I'm sure it'll be something, but there's newer development located at 168 Rivington, which is on the south side, as well as which are 4 sets of semis that were severed, and that construction is fairly recent, and no road widening was taken at that time.
Thank you, Mr. Price. I believe you want to make a comment, Mr. Harrigan?
Thank you. Through you, Mr. Chair, I would like to add just a few additional comments to my colleague, Mr. Kokonen. Road widening, as I've said before, this is a black and white policy within the official plan. We do take road widening on cul-de-sacs all the time throughout the every village, every urban area. We do this very consistently, and it would not be fair to those other applicants who have done road widening to remove this condition. In regards to the road widening, there was more than that does go on for road maintenance, which is important to take this road widening than just extending the actual road to make it from 2 lanes to 4 lanes. There's issues with drainage, power lines, sidewalks, any of these number of issues that the planning department and the transportation department will have to go in and make these upgrades over the next 20, 10, 30, 50 years, 80 years. This is the only time that road widening can be taken. And the official plan is 100% clear that there are no exceptions. The road widening is meant to be taken, and frankly, it sets a dangerous precedent to start using discrepancies to try and see if we can remove road widening when it very clearly says that it is to be taken. Those previous applications, they were done before this directive on an official plan for the road widening itself too. These applications benefit directly from this infrastructure, and it's very clear that these applications are to be to the benefit of this infrastructure as well too. This is a critical component of city infrastructure and maintaining and enhancing it for the long term. And this is something the department is fairly firm on. Again, as previous applications, I would ask that if the applicant, Mr. Price, wants to have this condition removed, that the onus of taking this to the OLT to appeal it should be on him, as this isn't a clear black and white policy from the official plan.
Thank you, Mr. Harrigan.
Thank you.
I'd like to ask the panel for their comments. Mr. Lewis?
If I could put a lot shorter spin on that, if I may, if the official plan ruled everything, then we might as well just all quit right now and just put it on the wall and kick it off. We can outrule the official plan in reasonable and common sense things. Mr. Price has heard the threats before going to the OMB, and it'll be appealed and one thing another. I say if he wants to take the road widening thing off, I'm 100% in favor of taking the road widening condition off and see where it goes. Thank you.
Thank you. Mr. Otto, any comments?
Agree with Mr. Lewis.
Thank you. Ms. Chandler?
I don't really understand the rationale for this being an exception to the road widening request, to tell you the truth. It's a developed street. It's a short widening. Like it's not a great distance. It fronts on the properties. I don't mind leaving that condition on in this case.
Thank you.
I don't
Mr.
have a
Vort.
concern with the applications in general.
Okay, thank you. Mr. Vort?
Just a couple comments. I think if we grant the road widening, then it affects all the variances that we approved on application number 1. Because I think it reduces all the lot lines. I just like clarification on that, because we approved all the variances for setbacks and lot coverage and lot size for lot areas. So can I get some clarification from planning on that? Because if the road widening is approved, then I think the variances we approved are going to have to change.
Mr. Kokonen?
Pardon me. Mr. Harrigan, are you able to comment on this?
Yes, through you, Mr. Chair, I would like my colleagues on the other end of the internet just to see if they have to confirm this. But section 3 of the bylaw states that if something is deemed zoning compliant before a conveyance or expropriation, it will be deemed zoning compliant afterwards. So to my understanding, if you do approve this minor variance for the front yard setback, that does make it zoning compliant. And then if you take that expropriation, it still goes back to that minor variance that has been approved.
Okay. Well, that's fine then.
Thank you very much.
In that case, then I would agree with Ms. Chandler's comments for the road widening.
Yes, Ms. Chandler.
Could we just stand this down until Mr. Harrigan has confirmation of that?
I do have confirmation. My apologies to you, Mr. Chair. I did just receive confirmation that that is correct.
Okay, thank you very much. Yes, Mr. Price.
Sorry, thanks. And that's all well and good, and I understand that. Is there something, and Mr. Harrigan, maybe you can help answer this question for me, because the issue always comes up that all us nice folks in the committee meetings, we agree that that's okay. So then, you know, as proposed, even with the road widening, this development as approved can proceed. And then when I get into the nice people at building services, then it gets into a bit of a conundrum. Is there something that can be included in the decision to that effect, or something in writing that I can get from staff that is indicative of that, so that once approved and we get through the appeal periods and whatnot, and we file our building permit submission, I'm not left with this 6-week back and forth between building services and myself to make sure that that's interpreted appropriately. That's the biggest concern with the road widening, to be quite honest with you.
Mr. Harrigan? Is there something
Through
can
you, Mr.
provide?
Chair, that is a very valid concern. Perhaps that the decision letter for the minor variance could include a note at the bottom there, just a condition stating that the minor variance was approved as per the original lot line before the road widening was taken. Maybe some note to that just states very clearly that the minor variance was approved as per the original lot lines before that, and that is to apply with the building permit.
That work, Mr. Price?
That is exactly what I'm looking for. So thank you very much, Mr. Harrigan. I appreciate that explanation.
Thank you very much.
I've run into issues before where, you know, it's approved and then the conveyance happens and you go to get your building permit and you're into a whole world of hurt. So thank you very much, everyone. I appreciate that.
Thank you. So now I'd like to ask the panel for approval of this application with all 5 conditions. All those in favor, please raise your hands. All those against, please raise your hands. Are you for or against, Mr. Lewis, or are you frozen? Can't hear you.
Get the mute off here. This road widening makes totally no sense. If the neighbors, no road widenings are there, and here's a road widening, I approve that. I agree with the severance, but it's getting out of control, these conditions. Anyway, I approve this. I'm happy with the severance.
Okay, thank you very much, sir. So your application number 10 has been approved. Thank you, Mr. Price. Now we'll move on to application number 11.
Mr. Chair, I think just for the record, we should indicate that Mr. Otto and Mr. Lewis approved the application, but dissented on the road widening condition.
Yes, can we please note that, Madam Coordinator? Thank you. Moving on to application number 12. Here again, we've got no concerns, Mr. Price, from planning, and same thing for conservation partners. So the panel notes that. There are also, if this application is approved, there are 8 conditions. Are you familiar with those conditions, and do you agree with them?
Yes, I do, Mr. Chair, subject to our previous discussion on the prior application. Yeah.
So you're having to do with, so condition number 4, the road widening, you want to have those comments inserted as well?
Yes, please, just for clarity's sake, because there's so many different decisions that'll be issued. I just want to be safe.
Okay, thank you.
you.
So I'd like to ask the panel now for approval of this application with all 8 conditions. All those in favor, please raise your hands. Your application has been approved, Mr. Price. Thank you very much.
Mr. Chair, sorry, I think probably we should note, I'm assuming Mr. Lewis and Mr. Otto disagree on the road widening condition on that.
Do you disagree, Mr. Otto and Mr. Lewis, on the road widening condition?
Of course, I disagree with it, but just whatever planning wants to do, that seems to be the in thing.
Mr. Otto, same comment, basically?
Basically, yes.
Okay.
Thank you.
So we'll note that Mr. Otto and Mr. Lewis both approve of this application. However, they are not in favor of condition number 4. Thank you very much, Mr. Price. Your applications have been approved.
Thank you, Mr. Chair. Much appreciated.
Now we'll now move on to items in order, beginning with application number 2, having to do with 6684 Harbor Street. Mr. Shipman, are you available? Good morning, Mr. Shipman.
Good morning.
I need to administer an oath concerning the signposting on the property. Can you take that oath this morning?
I can.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
I do.
Thank you very much. I know we've got a couple of administrative items to adjust and having to do with the frontage of the property. I believe the frontage should be 77 meters on Cannon Smith, not 50.
Correct.
I believe that the depth should be 109 on Cannon Smith Drive. Is that correct?
Yes.
And similarly, yes, having to do, the lots will be the same size, basically, both items, both lots.
Correct.
And the retained land will have a frontage of 156 meters, not 210.
Correct.
Great. Okay, I note that for the panel notes that the planning department doesn't have any concerns, but does have 6 conditions. Are you familiar with those conditions, Mr. Shipman?
I am, Mr. Chair. We've reviewed them and they're prepared to move forward based on those conditions.
Thank you very much. I note the Conservation Authority recommends that lot lines the proposed severed lot to increase setbacks from the wetland. Has that been resolved, or can somebody address that on behalf of the conservation partners?
Mr.
Yes.
Chair, oh, I'm sorry.
Yes, Ms. Ogden.
Thank you, Mr. Chair. With that noted revision in the lot sizes that you've just read into the record, the Conservation Authority is satisfied with the application.
Thank you very much. Mr. Shipman?
Yeah, that's exactly what I was going to say. Yeah.
Perfect. Great. Thank you. Now I'd like to ask panel for approval of this application with 6 conditions. All those in favor, please raise your hands. Your application is confirmed. Thank you very much.
Thank you.
Mr. Shipman. Now move on to application number 3. Having to do with 241 Timber Lane. Mr. Thaw, are you available? I see you there, Mr. Thaw.
Hello.
Good morning.
Morning.
I would like to administer an oath concerning the signposting on the property. Can you take that oath this morning?
Yes.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you
Yes.
swear?
Yes, I do.
Great. Thank you very much. So I note that there is some concerns, and so if you wouldn't mind just briefly going through some of your presentation, please, on your application.
Yeah, it's essentially through you, Mr. Chairman. The application is to provide a lot line adjustment. Thank you for pulling that up. To convey part 2 on this draft reference plan to the abutting lands to the south, being parts 3 to 8. The lands parts 3 to 8 are also owned by the applicant, my client. And the concerns of the staff relate to the new OP requirements on minimum hectares. But based on the staff planning comments, they don't see any issues with the application. One, because it's legal non-conforming use. But 2, the wording of the OP states that it relates to the creation of new lots, whereas here we're dealing with just the addition of a piece of land to the abutting lands to the south. The only item that I would ask, Mr. Chair, if you don't mind, is Mr. Kukanen and I had a discussion last week just about the fact that there's a requested notice as a condition to be registered on the retained lands, just relating to the quality and quantity of water, which I'm sure the city would not like to warranty anyways. But we just asked that since the abutting lands are already serviced with septic and well, that the condition is just clarified to say that the notice is put on just the retained lands, so 241 Timber Lane.
Okay, thank you very much, Mr. Thaw. Mr. Kokona, do you have any comments on behalf of the city?
Through you, Mr. Chair. Yes, so as outlined, our concerns were mainly due to the official plan wording and the lot size is dealt with in the official plan. These are pre-existing lots that do not fit the minimum lot size requirements, and therefore we just wanted to note those concerns. This will be addressed through the condition for the notice on title with the quality and quantity of the groundwater, and I can confirm that those are to be applied to the retained lands.
Thank you, Mr. Kokona. So, Mr. Thaw, there are two conditions. One, Mr. Kokona just touched on. The other one is a standard lot line adjustment condition. Are you familiar with those and you agree to them?
Yes, I am.
Okay, perfect. So to that end, I would like to ask the panel for approval of this application. All those in favor, please raise your hands. Your application is approved, Mr. Thaw. Thank you very much.
Thank you very much, Chairman.
Now moving on to application number 4 concerning 437 Donald B. Monroe Drive. Mr. Arjun Sewer, are you available?
Yes, I'm available.
Good morning.
Morning.
Can you take an oath concerning the sign posting on your property today?
Yes, I can. Yeah.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
Yes, I swear.
Thank you very much, sir. The panel notes that there's no concerns from planning and no concerns from the conservation partners. And to that end, I'd like to ask the panel, and there are no conditions. So I would like to ask the panel for approval of this application. All those in favor? Your application is approved, Mr. Stewart. Thank you very much.
Thanks very much.
Okay, moving on to application number 5, having to do with 6446 Prince of Wales Drive. And Mr. Pence, are you available?
Good morning, Mr. Chair. I'm here today. My colleague, Kamal Chayumi, will be joining me as well to speak on behalf of the application.
Thank you very much. Which one of you would like to take the oath concerning the sign posting on the property?
I'll take the oath.
Go ahead, Mr. Chonu. I would like to, so do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
I do.
Thank you very much, sir. I note that there are no concerns from planning nor any concerns from our conservation partners. However, there are 7 conditions should this application be approved. Are you aware of these conditions, Mr. Chonui?
Yes, I am. And we agree in principle with all the conditions. We would just note that with condition number 8, item B, we think it might be a little premature to be determining the location of a tree at this time, given that there's no development plans for the severed properties or the proposed severed properties. So we would just note that it might be a little premature at this point to be requesting that.
Okay. Just to correct you one little bit, the condition number 7 had to do with the drainage and drainage plan. That's been removed.
Sorry,
I think
condition
you're
8.
discussing 7. You're talking about condition number 7 now. It's just been changed.
Oh, it's been changed. I see. Okay.
Yeah, because number 8, number 7 has been removed, and then number 8 is now number 7.
Okay, so condition number 7, item B. Yes.
Okay, Mr. Harrigan, do you have any comments on that?
Thank you. Through you, Mr. Chair, the village secondary plan is abundantly clear that lot creation within the village is supposed to go through a plan of subdivision to mainly achieve three objectives. The one of them is any road connections or new roads that need to be built. The second one is any connectivity or parks plan. And then the third one is just to make sure that the design options, particularly vegetation, are implemented. There are no options for road connections or new roads, and similarly, the parks and connectivity plan doesn't extend here. So we are satisfied the plan of subdivision is not required, but it really does hinge on planting these vegetation is to satisfy this official plan requirement. I can understand the concerns about planting the tree at this time. I have had a chance to speak with the infill forester, and they have no concerns with planting it. The smallest lot at just over 50 meters wide does provide ample room to plant a tree and to have lots of options for a driveway to go on either side. I've noted that in the previous conversation with the applicant that the secondary plan specifies that driveways are supposed to go along the interior lot line, not along the side of the house, and then either have parking at the side of the house or the rear of the house. So planting a tree right in the middle of the lot line would allow for a driveway to go on either option. They also have 2 years to plant the tree, so that's a lot of time to design and plan out a house and where the tree could potentially go where it would have no impact with the driveway. So there is lots of flexibility to this. I understand that we are asking it to be planted in advance of the severance, and it is appropriate in this case as determined by the infill forester.
Thank you, Mr. Harrigan. Now I'd like to ask panel for approval of this application with all 7 conditions. All those in favor, please raise your hands.
Mr. Chair, I just wondered if Mr. Chownie had any response to what Mr. Harrigan just said.
Mr. Chownie?
I mean, generally, we would just say that currently there's no development plans. There's no agreement to sell the proposed severed properties. So in terms of citing septic systems, a dwelling along with the tree might complicate things. But if the committee thinks it should be required, then we will accept.
Thank you. Ms. Chandler, you have a comment?
The tree planting plan, just quickly, the nuts and bolts of it. Would it be a plan that would then be part of a development agreement on both properties? How many trees are required? What are sort of the standards that would be expected? Because that does sort of play into Novatech's comments about how executable it is.
Harrigan?
Thank you. Through you, Mr. Chair, it is 1 tree on each severed lot and 1 tree on the retained lot. So just 1 tree per lot that has to be planted, and it would be planted in the front lot, in the front yard. So that would leave ample space for the dwelling to be located behind it. Any septic systems, wells, these lots are quite large at about 0.6 hectares to 0.72 hectares. So there's ample space to have this 1 tree located in the front yard while still providing an abundance of options and availability for driveways and dwellings and septic systems into that regard. And again, the reason why the planning department is proposing this tree planting, not as a development agreement. Like we would like to see this tree planting actually occur before finalizing the severance, and this would avoid us having to take any unnecessary securities, development agreements, inspections. This would really simplify the process considerably while still allowing a lot of flexibility for the homeowner and the applicant in where they would like to place this tree and designs for the future. We're trying to be as absolutely realistic as possible and understanding and make this not a difficult process. It's just would just be 1 tree. The nuts and bolts of how this would actually work out, we've recommended to the applicant that they contact the city infill forester just to identify where they're proposing the tree and what tree species. After that, they plant the tree, send us a picture, or if need be, the infill forester just does a quick site visit, and then the condition would be cleared. We would ask that there's a notice on title just be placed that just says the trees are to be protected through any future development, but that notice on title would be registered within the same agreement as the groundwater covenant. So it would be no additional cost or any unnecessary fees for that. So again, we're trying to make this as simple as possible while still satisfying the vegetation planting requirements of the official plan.
If I can just ask one question, why would the option of just including in that notice on title not be that in order to receive a building permit, a tree must also be planted in the front yard?
Thank you. Through you, Mr. Chair, there is difficulty with the vegetation planting in terms of the building permitting, just through their scope of review with the building permitting department, there is difficulties with vegetation inspections as it relates to building permitting. So it's an internal process that is difficult to enforce strictly through the building permitting side of that. So at this point, having it done in advance ensures that it is done, and yeah.
Okay, thank you. Mr. Lewis, do you have a comment? Sorry, Ms. Chandler, go ahead.
Sorry, I'm just gonna, look, it's not a very onerous ask of the owners to ask them to plunk in a couple trees at the front for the purpose of completing a severance. So I'm not going to suggest that we remove this condition, but I do question the powers of the building department with respect to ensuring trees are planted, given how they execute tree removal and infill through the building permit process and take deposits. So I'm not going to, anyways, I think I'm okay with the condition because I don't think it's particularly onerous, but that's when I would like to see some additional thought and information come from the building department on the future on why this can't be executed at a development stage, when on a smaller lot, planning out the location of the tree could be really important.
Thank you, Ms. Chandler. Mr. Lewis.
Well, I'm just not sure why we're even talking about this. Can we not just go down to the Walmart? I think they're $50. Buy 2 trees, jam them in, conditions cleared. Like, this is one of the easiest things the planning department ever come up with. I approve the application with the 2 trees. Thank you.
Thank you, Mr. Otto. You're muted, sir.
I have a question basically not on this subject, but on the road widening on Prince of Wales. Only 11.5 meters. I believe Prince of Wales used to be a provincial highway, and it should at least still be an arterial road. So is that 11.5 meters correct? And that's a question for the planning department.
Mr. Harrigan.
Thank you. Through you, Mr. Chair, that is correct. This portion of Prince of Wales within the village has a separate road widening requirement from that outside of the village. So within the village, the right-of-way protection currently is 23 meters. So half of that would be 11.5. I understand that the confusion, I do have it myself, but it's just the road changes its right-of-way requirement as it moves outside of the village, presumably because you can increase the speeds dramatically outside of the village.
Thank you. Does that answer your question, Mr. Otto?
More or less. It answers the question, but it doesn't make sense to me. And the fact that where you've got increased population, you actually need wider roads than you do out in the country. Never mind the speeds. It's just, anyways, it's one of those things I guess the planners have decided is the right thing to do. So I'll accept it.
Okay, thank you. Mr. Vervoort?
No comments or questions. I agree with Mr. Lewis's comments.
Okay, thank you very much. Now I'd like to ask the panel for approval of this application with 7 conditions. All those in favor, please raise your hands. Your application is approved, Mr. Chairman. Thank you.
Thank you, Mr. Chair.
Okay, moving on to application number 6. This application has to do with 135 Heather Street. Mr. West, are you available? Mr. Polton, good morning.
Good morning.
Are you replacing Mr. West this morning?
I am, yes. Mr. West has left Novatech to pursue other options, so I'm acting as agent on behalf of the owners for this file.
Thank you very much. I'd like to administer an oath concerning the signposting. Can you take that oath this morning?
Yes.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed, was clearly visible and legible during that time? Do you swear?
Yes, I swear.
Thank you very much, sir. So the panel notes that neither planning nor the Conservation Authority have any concerns with this application, but there are 4 conditions. Are you familiar and do you agree with these conditions?
I'm familiar and I do not agree
Okay.
with all of the conditions.
All right, which ones do you not agree with?
Okay, so I do understand that condition 1 is the standard condition for lot additions. I have no concerns with that. I also understand condition 4 is required to withdraw the previous application that's been approved to finalize this application. So I agree. It's conditions 2 and 3. We were a little disappointed to see conditions requested on this lot addition. That's different than the conditions that were approved for a previous lot addition from this application where these conditions weren't requested. So this has to do with the development. Sorry, this has to do with an agreement from the city. Has to do with the quality and quantity of groundwater is condition 2, and condition 3 is for the soils, the karst topography. We feel that this isn't necessary. It's our understanding, and city staff would have to confirm this, but it's our understanding they're requesting this for just the retained lands, not the lands to be severed and added to the property to the south. But even so, this agreement wasn't required for a previous lot addition from this application to another adjacent residential property. And specifically with condition 2, we have concerns with how it's worded. I understand it's the city's standards condition saying there don't guarantee the quality and quantity of groundwater, but there in paragraph 2, which is the requested agreement, the last statement it says, note the following exceedances for some drilled wells, and then it goes on. We've seen this condition imposed previously on other applications, but we've never seen this wording. And just looking at the wording, it references drilled wells within 500 meters of the site, and then lists exceedances. We don't know anything about these wells, where they're located, how far away they are from the property, their design, their depth, or when they were tested, or the extent of the exceedances. So we don't agree that it's appropriate to include this on a notice on title that landowners potentially buying this property 50, 100 years from now would see this information. It's potentially, it's encumbering on title. Groundwater situations change over time. Given the lack of information as to what this actually means, I don't think it's appropriate to add. So that would be my comment with regard to condition 2.
Okay, thank you. Mr. Kokona, any comments on behalf of the city?
Through you, Mr. Chair, thank you for those comments. I can confirm that the reason for these requested conditions, these were identified by city staff as potential concerns with the developability of this retained parcel going forward. So we wanted to include these notices on title for any potential buyers or property owners in the future to outline what may be required to develop these parcels in the future. It could be a great additional expense, and we feel that the future purchasers should have a right to be aware of that. And that's where we are coming from on these 2 conditions. With respect to the additional information included in condition number 2, this is information that we may be able to provide if the application were to be adjourned. However, this is just additional information that we wanted to relay to anybody, but if we are in the position that if this wording is requested to be removed, that we are satisfied with that.
Okay, thank you, Mr. Kokona. I'd like to ask do you agree with that, Mr. Bolton? Are you?
I would agree, like if conditions 2 and 3 are imposed, I would agree with changing the wording of condition 2. We're hoping like I would just like a better explanation as to why this wasn't requested previously on like other applications. This odd to see that these conditions are requested for this application, but it wasn't previously. And in terms of the development of the retained lands, it's an existing legal non-conforming landlocked parcel. There will be challenges with developing it in the future. They'll have to provide frontage on a public street. There'll be separate application processes. The retained land size is greater than 1 hectare. And so in terms of developing it in terms of size, quality and quantity of groundwater and karst topography, I mean, it's in the middle of a existing residential subdivision. I don't see it being treated any differently. And again, this is already a notice not on title of this existing landlocked parcel. We're not proposing any development. We're just adding lands to an existing residential property to the south. So we would prefer if those conditions aren't imposed for an agreement with the city. If they are imposed, we prefer condition 2 be amended so that that note is not included.
Okay, thank you very much. Now I'd like to ask the panel for, sorry, Mr. Conan, anything further?
Yes, if I could just add one more further comment. This is due to the changes in procedure through our review with the new official plan, and we are more diligent providing information to potential future owners. That's where we are coming from with these 2 new imposed conditions. And in addition to that, with the proposed lot line adjustment, we are significantly decreasing the size of the retained lands. So that is why the water and soil conditions are of particular concern.
Thank you. Now I'd like to ask the panel for their questions or comments. Mr. Vervoort?
I don't have a problem with imposing conditions 2 and 3 with the modification to condition number 2, removing the specific references that Mr. Bolton indicated he wanted removed and which planning has agreed to.
Thank you. Mr. Lewis?
I'm happy with the revised condition also.
Thank you. Mr. Otto?
I'm happy with the revised condition. It just seems to me that we're getting more and more onus on people that are doing simple lot line adjustments and imposing more and more conditions. But I'm fine with the changes made suggested.
Thank you. Ms. Chandler?
I agree with the rest of the panel.
Thank you. I'd like to ask the panel to approve this application with the amended condition number 2. And so there will be 4 conditions still on this application if approved. So all those in favor of this application with 4 conditions and amended condition number 2, please raise your hands. Your application is approved and amended. Thank you very much, Mr. Bolton.
Thank you very much.
Moving on to application number 8. This has to do with 1364 to 1370 Stittsville Main Street. Mr. Price, are you available?
Good morning again, Mr. Chair, members of the committee.
Good morning. Can you take the oath concerning the signposting on your property?
Most certainly can.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
I swear, Mr. Chair.
Thank you very much. I note the panel notes that there are no concerns from planning nor concerns from or objections from the conservation partners. To that end, I'd like to ask the panel if they would approve this application. All those in favor, please raise your hands. Your application is approved, Mr. Price. Thank you.
Thank you, Mr. Chair, members of the committee. Easiest one ever. Much appreciated.
You're welcome.
Take care. Bye.
On to application number 10. 9, 10. Application number 10 has to do with 1675 Carson B Road. Ms. McKenzie, are you available? Good morning, Ms. Zander.
Morning, Mr. Chair, committee members.
Are you on this file?
I was not originally, Mr. Chair, but Ms. McKenzie retained me just to help her get across the finish line here and help with the conditions. So she is here this morning. I'm not sure if the signage oath has been taken in the past, but she can take that and then.
Okay. Ms. McKenzie, can you take the oath concerning the sign posting on your property? You're muted, Ms. McKenzie. There you are. Good morning.
Good morning.
Can you take the oath this morning for your sign?
Yes, I can. Yeah.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing, as instructed, and was clearly visible and legible during that time? Do you swear?
Yes, I swear, yes.
Thank you very much. So, Ms. Zander, I note that the panel notes that there are no objections by planning, but there are 7 conditions and there's no concerns from the Conservation Authority. Are you familiar with the 7 conditions and do you agree with them?
Yes, I am, Mr. Chair, and Ms. Mackenzie and I have reviewed them and have no concerns.
Thank you very much. So to that end, I'd like to ask the panel for approval of this application. All those in favor?
Mr. Chair, sorry to interrupt.
Oh,
I just
yes.
wondered do we have to deal with the frontage issue? Because technically the road frontage is 0 right now.
One of the conditions I think Ms. Zander addresses that. Is that to your satisfaction?
Yes, my client and I understand the requirement to extend the road, which will create the required frontage. But I agree with Mr. Revort, the way the application is shown in both lots show with 0 frontage, but one of the conditions will require the road to be built in agreement with the city, and that will meet the frontage requirement.
So we'll note then that their frontage presently is 0.
Yeah, because I just wanted to point out, because in the notice it said 107, but it's actually technically it's 0. So I just want to note that for the record. Thank you.
Yes.
Thank you, Mr. Revort. So to that end, I'd like to ask the panel. Yes, Mr. Lewis.
Just one quick question. How much road needs to be built? Maybe in here, but I can't find it.
Well, I'm not quite sure yet. I don't have any plans at this moment for both the lots. The second lot may not ever, nothing may not ever happen to it. So if I build a house, it would be for myself. On the first lot, I would only extend the road as far, it wouldn't go to the end of the first lot. It would just be enough to satisfy the requirements in the EIS and the allowance for the driveway.
Well, my question is, maybe this is where, maybe it's not a problem, but if 2 years to do it, if the road doesn't get built to both lots, does the second lot lapse?
Maybe Mr. Harrigan can help with that.
Thank you. Through you, Mr. Chair. Presently, the road ends approximately about 160 meters before the second lot. So it'd have to be roughly 165 meters to be extended to reach the second lot. The application, the condition itself, the way it's worded, just states that they have to complete the road extension application. So they need to complete all the necessary technical studies that would be associated with that, the drainage, the grading, the correct geotechnical investigation report, and to that regard, and then pay all the necessary security. Ideally, it would be done within the 2 years, but they need to pay the security so that to clear the condition. So have the complete application, securities done to clear the condition, and then after that, it could clear the condition, but no building permit will ever be issued until the work is actually completed.
Okay, so the lots can be registered as long as the securities are paid, but the road does not have to be built, but the road has to be built before the building permit. That makes sense, if that's what I'm thinking.
That is the way the condition is worded presently, yes.
Thank you very much.
Can I just ask one? I'm sorry. Could I just ask one question of the condition number 6 about the revised EIS?
Sure.
Where at what point do I have to do a revised EIS, and where? I'm not quite sure. Is it on the whole, the two severances in the road again, another EIS?
Mr. Harrigan, can you answer that on behalf of?
Through you, Mr. Chair. For the severance application, we need a revised EIS just because the descriptions as it related to the water courses that were there just needed to be updated for the information and record keeping purposes. And that was a conversation between your EIS consultant and the city environmental planner, just of what work need to be done. So that would clear that condition once we just have the revised EIS specifically addressing just the water courses there and the descriptions for that. And that would clear that condition. When you come in for a road widening or the road extension application, You may be able to use the existing EIS, but it may require some modifications depending on the exact work that needs to be done. So if there's additional culverts that have to be created for those 2 water courses, or if there's any concern about how much it needed to be widened, then there might be additional discussions that are required. But specifically for the severance application, the only revisions that we were looking for is just an updated discussion on the water courses that were there.
Okay.
Thank you. Now I'd like to ask the panel for approval of this application with all 7 conditions. All those in favor, please raise your hands. Your application is approved, Ms. McKenzie. Thank you very much. Thank you, Ms. Zander.
Thank you.
Thank you.
Thank you very much.
I think that's the last application today. Is that correct, Mr. Coordinator?
Yeah, that should be all of them.
That's great. Thank you very much. Thank you, everyone, for your help today. See you in a couple of weeks.